Hello and welcome to Legally Speaking with me, Tarin Nangia. We are back to our much popular and well-regarded series, which speaks about when civil cases are turned criminal or you foist a criminal case on what is a civil dispute in order to force settlement with the other party. And how this is done mischievously and what impact it has is what we discussed in part one. In part two, we're going to take this discussion further for your benefit so you understand why this practice is becoming widespread in India and the dangers that are associated with the same. I have with me to speak on this topic yet again, Advocate Vikram Singh. And as you would know, he practices at the Delhi High Court and the trial courts. As also he's associated as a partner, which may I call a founding partner at Circle of Counsels law firm that specializes in financial crimes. Good to see you, Advocate Vikram Singh, and looking forward to some very interesting insights on this really interesting topic.
Thank you, Tarin, and I'm glad we can contribute for our viewers and the legal community this particular aspect of litigation, which is creating ripples across the legal fraternity and has impact not just on individuals, but on the society as large in the first place.
And, let us begin with my first question in part two. We will take on from part one. And this practice of fostering a criminal case and what is essentially a civil dispute or turning a civil case into a criminal case, why is it becoming widespread in India? And what are the dangers in your view that are associated with this kind of a practice happening in this country?
Thank you, Tarin. As I said, so that previously this particular model was adopted by mischievous litigants to meet the ends by using the process of law and to settle civil disputes by giving them the color of a criminal act. But unfortunately, the situation has aggravated a lot further. As we all learn from each other, now this particular aspect of settling civil disputes and clouting the civil proceedings or something which is of a contractual nature, the problem has come from the domain of personam to the domain of rem. That is not just the individuals or related parties or contractual parties that are adopting this particular methodology to resolve their dispute, but lately this particular aspect has been noticed with financial institutions as well. With law enforcement agencies, those who often take suo motu cognizance of the events around in the economy as such. And this particular aspect is also visible wherein corporations which suffer business loss by change in technology or by the innovations in the sector, irrespective of their fact or by the stiff competition like the collapse of Go Air, which is attributable to the industry as such, which is a very difficult to survive industry. That's the airline in spite of its boom. So I'm hereby noticing lately that this chronic problem is aggravating. Now, what is most important to be looked into is what is causing it in the first place. As you asked me why is the practice becoming widespread. See, the objective of an individual does not differ much from the objective of a corporation, from the objective of financial institution. Everybody wants to resolve their dispute, come out on the top if there is a conflict of interest, and they don't hesitate in adoption to this. Now, I'll give you a particular illustration that wherein I have noticed, and you'll be shocked to know that even resolution professionals, if they are unable to resolve the company once CIRP process starts within stipulated period, they are also under the shadow of doubt that they have taken over a sick business. And it was expected of them to resolve and find a resolution process. And why this particular CIRP process has not been completed in 180 days. So therefore, this particular problem has aggravated a lot. And in fact, as we know that not just the financial institutions, where we are noticing that if you default on a particular promise to pay the money back, or if you're defaulting on the loan, without giving an opportunity to explain or without the adoption of all the alternate party principles of natural justice, you are being declared as a willful defaulter. Now, without an opportunity, I'm being declared a willful defaulter, then thereafter, my account is being declared as fraud. Now, this particular practice, though it has been lately checked by the Honorable Apex Court, but these are all reflections of this mindset across the industry and across financial institutions, that as long as they can give a color of criminality to a civil transaction, they can achieve anything. Banks can achieve the recovery in the least possible amount of time. They can unleash the vendetta and achieve their objectives. And the net result, as we stated in the last episode as well, is the incarceration of a person. So therefore, there are various reasons that this is widespreading, because for every cause, whether it is from a financial issue, from an individual, from a corporate commercial dispute between two legal entities, they all want to come under the asylum of criminal law, because it sends ripple across the other side, and they do most likely come on the best terms as per the complainant and as per the parties who initiate the criminal proceedings.
Point well taken. And if somebody is fallen victim to such an act, where a criminal case is being foisted in a civil dispute, how one should effectively deal with the same, and also how to effectively deal with this menace, because it is a problem for society at large. And what is the correct legal remedy in such cases? Could you explain both these things?
Yes, I would love to, because at the end of the day, the salvation lies in the asylum of legal proceedings at the end of the day through the hands of the Honorable Court. So in this particular aspect, where a person finds himself on the other side, on the receiving end, that somebody has instituted, foisted proceedings, criminal proceedings upon them, when the nature of transaction and relationship between those particular individuals or corporation was of absolutely civil in nature, and they have been just created and manufactured by the other side to resolve this particular dispute, issues, or on their terms, the best and the foremost option is going to be that we approach the courts at the very threshold, at the very inception, once we notice that the person has been alleged of committing a criminal offense from the other side. Now, why do I say that the legal remedy should be adopted at the very threshold, at the very stage of inception, is because courts are the only agencies which can actually understand the thin line of difference between a civil dispute and what constitutes a criminal dispute in the first place. These particular kind of disputes are not being able to properly scrutinized by investigation agencies. They also struggle to come to a conclusion whether the dispute is civil or criminal. But the courts, and especially the superior courts, are competent enough, not just competent, we learn from them, they make the law. They pick up very soon that this particular person has been a victim, wherein the civil proceedings has been converted into a criminal matter altogether as such. Now, the remedy which I believe, though not always successful, is the remedy of quashing the proceedings at the threshold in the first place. It is difficult. The chances of success are very limited, as everybody in the fraternity knows that quashing is not the norm. The norm is the investigation, because the other parties also have their fundamental right to get their allegations investigated by the state agency. But nonetheless, there are settled principles as such that wherein if the court finds those particular elements in the particular case, they are not hesitant to give relief to the petitioner at the very inception of the litigation challenging the criminal proceedings foisted upon them.
Okay, you can continue then, ask.
Such as we have to be careful if the allegations are emanating from a contract. Now the courts are competent enough, and the courts certainly can distinguish whether the allegations or averments in the complaint prima facie constitute a criminal case, or they are just twisted and tainted by a smart draft in the first place. The court can also look into the fact whether the FIR disclosed a cognizable offense and whether an investigation is justified in those particular allegations or whether those particular allegations do not constitute an offense as such. The court also look into the fact that whether these allegations, if they go uncontroverted, whether they constitute any commission of any cognizable offense in the first place or not. And courts are also cognizant of the fact that whether the complaint is disclosing a cognizable offense, the complaint is disclosing a non-cognizable offense as such, or what can be the approach of a prudent person is best adopted by the court as well. So once the court find themselves coming across a matter where parties were into a contractual relationship where a civil dispute is pending between the parties as such, in those particular circumstances, the court, if they find that the allegations, the averments in the FIR, they don't constitute any criminal offense. On the bare perusal of the same, there are no elements of the offense which are made out. They do come to the rescue of the petitioner, and henceforth, the right approach at the threshold is going to be knocking the doors of the court under Section 482, Article 226, 227 of the Constitution of India, and thereby approaching the court for an instant relief. Yes, please.
Point well taken. And we will now go to a follow-up question that, okay, but I mean, I have a question when I heard you, and before and after that we go to the next phase of our discussions. Have you ever seen instances where it becomes very difficult for a person who's framed in a false criminal case to extricate himself? Are courts sympathetic when you tell them that, oh, we have a civil dispute and now, the criminal case is being foisted? Is the system sympathetic, or you are treated as harshly as any other, in a sense, accused?
No, the courts are very sympathetic, Tarun. The courts are very sensitive for this cause. The courts are conscious of the fact that what's been going on lately in the circles of investigation agencies, before the law enforcement agencies, or people are abusing the agencies, the law enforcement agency, the rules, the procedure as such. The courts does extend an arm of empathy to the petitioner as such. The courts are very sensitive for this cause. That's why I said that if you are confronted with a situation where a criminal proceeding has been alleged against you, and when you are completely confident of the facts that yes, I have not done anything wrong, that you will find the courts to be very conscious of the same, the courts to be very sensitive to you, and the courts do hear the petitioners at length, though they are not obliged to hear at length, because all that the court has is just a copy of FIR in their hand. So it is very difficult to determine whether the allegations have substance or not, because the investigation follows to the allegations. But nonetheless, the courts as they are, and because the honorable judges, we are blessed to have them, that they don't take much time to discover whether this particular FIR has been instituted with an ulterior motive, whether this particular complainant, who looks to be an educated person, who looks to be a prudent man, and he has come to adopt these criminal proceedings since the civil dispute has been pending for long, what can be the agenda behind it? What can be the motive behind the same as well? And the courts are also very conscious that whenever there is a complaint related to personal, like in personam, like between two private entities, between two individuals, and as long as it is not affecting the society as large, they do come to the rescue of petitioners, thereby not permitting the other side to resolve the dispute on their terms in an autocratic manner, and then too utilizing the arm of the state. Because if the courts are not sensitive enough, the message which goes to a common person that we are living in a police state as such, that anybody can decide anything on their terms, can force upon them to abide by it, and they have no remedy available as such. And lately the courts have been conscious enough of this fact, and this is reflecting in giving bails to this in these kind of matters as well. Courts have been time and again saying that where there is a dispute between two parties. Both the parties are in custody of all the documents which relate to the dispute. And these kind of economic disputes seldom require custodial interrogation because there are contracts, there are documents, correspondence which are in possession of vice versa, that is both parties. Either it can be given by the complainant to the agency or it can be given by the accused to the agency. So these kind of matters which are documentary based disputes emanating from contracts, dispute emanating from lease, tenders, financial in nature, related to a bank, as at the end of the day you always have a loan agreement with them as well. The court says, why do you need the person to be custodially interrogated as such? And what is more relevant out here, that the mindset with which the complainant adopts this kind of, I condemn this, I cannot call it a strategy, rather adopt this kind of methodology, which I grossly condemn, is they fear that if I can bring the thought of incarceration into the mind of the other party, then possibly they will heed to my illegal and extortionist demands in the first place as such. And the courts are conscious, they do not want that commercial disputes should be settled under the overcasting shadows of criminal law. There are procedures laid down under the civil law. We are encouraging the arbitration process so much as well. We have also made fraud as arbitrable as well lately. It was not arbitrable before. So henceforth the courts are encouraging this. And lately I have been hearing that the courts have passed strictures against judicial officers in trial courts as well, whereby they have not granted bail to a person who deserved it. So the courts are very sensitive for this cause. And this problem is going to be resoluted by the hands of the court only.
Point very well taken, that courts, as you said, understand with the passage of time that unfortunately, some people do use criminal cases to force settlement in a civil disputes. I think with time courts have been able to see through this malpractice, which is a good thing. Now taking this discussion further, do you see any reforms, if at all they are possible, in the legal system to help change this problem that now many people are facing?
Tarun, I'll just take the liberty to continue further on that just for a couple of minutes. That though you asked me whether the courts are sensitive enough for this cause, the investigation agencies are also waking up on this call as well. The investigation agencies are not that blindfold as they used to be, and they are careful in proceedings of economic in nature, at least between parties when it is interstate dispute does not affect the society as a large. There has been notifications with various law enforcement agencies not to arrest, but to let the party rebut the allegations against them, to let the party submit a counter version of the events and the facts, what has been alleged against them as well. And the provisions of Section 41A, various apex court judgments, which have carefully laid down the procedure to be adopted by police in economic offences. Slowly we are seeing a silver line from the end of the investigation agencies as well, as such into this. And therefore, this is very important. I will just take one more minute, because now what has happened that, as you know, Tarun, that one particular set of allegations can lead to an investigation by multiple agencies. And I'm talking about a criminal case. The same set of allegations qualify to be investigated by CBI. The same set of allegations qualify to be investigated under money laundering. The same set of allegations, if it's a listed company, qualify to be investigated by SFIU. The same set of investigation can be proceeding under various agencies. So therefore, though the system is evolving, but nonetheless, it is the courts who are leading the reforms into this. I agree with you. And now coming to your next question, that what possibly reforms can be associated with the same term. One of the most important things is that this is a colonial mindset which is coming up and hovering over our minds, that momentarily there is a crime, the best resolution is put the criminal behind the bar so he doesn't commit again a crime. But that was only qualifying for a blue-collar crime. What we talk about is a white-collar crime. A blue-collar crime committed by a criminal syndicate, such as kidnapping and all of that, there we understand that custodial interrogations are required. What is most relevant out here is that to come over this hangover by the investigation agencies, and what I believe that, see, the first person who meets a man who has been alleged to committed any crime is a police officer before he even goes to the court. So therefore, if the first agency which comes across a person when he is alleged to have committed a crime is police, so the reforms must begin from there itself as such. First, I will talk about that how reforms are required since long with relation to law enforcement agencies as such. Because if they don't bring the other side, that is the accused person, under the shadow of arrest, then obviously he will have sufficient time to prove his innocence at the stage of investigation alone. And there are provisions in law that FIR is not the end of the world. It can be closed as well. It may lead to submission of a final report, thereby elaborating the allegations, saying they have been proved prima facie and we are submitting the evidence. But there are enough provisions in law, in CRPC, which give enough rights to accused as well. So the first thing which is warranted out here, like the CBI does a preliminary inquiry. Not necessary in all cases, but a preliminary inquiry is warranted in all cases as such. In the famous case law of Lalita Kumari, which mandated that all cognizable offences must be converted into FIR, nonetheless also stated so that preliminary inquiries are must, because if the agency can determine in the preliminary inquiry itself that the facts do not constitute a criminal offence, the facts do not make out a cognizable offence, the facts, even if uncontroverted, come out to as a civil dispute between the parties, say, and the right remedy for the complainant ought to be going to the court and filing a civil suit as such. So therefore, in these preliminary inquiries, a lot of litigation can be nipped in the bud. Another reform which is also required at the stage of investigation is indulgence of senior officers. See, officers are ranked as per their qualifications as well. The qualification for a subordinate cannot be the same even for joining a service which is required usually for a person who's sitting high up in the hierarchy. So, and naturally, the senior officers are more qualified to deal with the economic offences. They are more qualified to guide their subordinates how to do the investigation. Unfortunately, they are also very overburdened, I don't deny that, but it is the proactive participation of the seniors and the constant monitoring of an economic offence by an agency will also result in, to a great extent, culminating this mischievous kind of litigation at the very stage when it is initiated altogether as such. Now, I can also say that there are some facts which can be considered by a particular investigation officer. For example, if he alleges something, whether the dispute emanates from a contract, from an agreement, naturally, he, as explained in my last episode, he will complain against the other side who's in the contract as such. Now, they can see whether the dispute relates to performance of the contract. If it relates to the performance of the contract and the other party has walked out, can it be an allegation of cheating? No, it cannot be. The remedies, such as in specific relief act for specific performance, if it relates to property or an action which the court can direct the other side to perform the same. The investigation agency can also look into the fact that what are the grounds on which the disputes has arisen. The investigation agency can also look into the fact whether the dispute is new or it has been long pending between the parties. There is a civil dispute going on, and after a lapse of considerable time, because Limitation Act is quite relaxed when it comes to criminal law. There are long periods of limitation, 3, 12 years to report an offence, and no limitation at all if it's punishable for more than 7 years. Then definitely they should also be looked into. And the court should also look into the fact whether the other party has some kind of an injunction on the subject matter as such, and that injunction has resulted into a dead end for the opposite party against whom injunction has been granted. And in order to overcome that injunction, that he can't overcome that injunction from the court, he has come to the doors of law enforcement agency, to resolve his problem, and he will be using them as a tool. The cost from the state, the machinery of the state, the officer of the state for a cause of an individual when the complaint itself is misleading, false from the beginning. So the reforms are more required at the stage of investigation agency as such. And there are enough provisos in CRPC which deal with the same as well. Just like there are various ways a criminal complaint can be filed, either through an FIR or under section 200 directly before the court as well, where the court can do an inquiry as well. There are provisions related to monitoring of the investigation agency as well. If you are alleged and by chance there is an FIR, one salvation can be that you can request, the complainant usually does that, for a court monitored investigation as well. The court can monitor the mischievous conduct of the IO, those who know that there is no offense, and Z act in the other way around, because nothing motivates a man like fear. And the fear of incarceration and losing your liberty is supreme. The law is all about, criminal law is all about keeping your liberty. So henceforth, these kind of reforms have to be done at the police level as before any other agency.
Thank you for beautifully explaining this. Also, the role of the police and the senior officers, which you mentioned at the outset. Of course, it is not rare that sometimes cases unfortunately do happen at the police level, where a person may feel implicated also. And that is where I think you said police reform is also essential. But most importantly, you highlighted the role that can be played by the senior officers in guiding in such cases. One thing I also take away from your interview that I saw in an interview that we did today was the economy of India is growing. So these kind of disputes, if not curbed, may actually grow exponentially in the coming years. Because with more and more money at stake, people will resort to whatever means possible to settle a civil dispute using criminal means. I know it sounds scary, but if that is the case today, it won't vanish away overnight. I think we would get the opportunity to discuss this aspect also with you, that what are the dangers we run as a society if this is not curbed. Today we are a $2.7 trillion economy. We may be a $5 trillion economy tomorrow, with thousands and lakhs of more disputes in every city and town of India, and the police and other agencies or the courts being misused by false complaints to settle these. So the dangers I would like to discuss with you in part 3 along with some anecdotes, but appreciate your joining us today and candidly sharing the current scenario and also certain reformative steps that you suggested in the last answer. Thank you, viewers, for tuning in. And finally, I would like to thank Advocate Vikram Singh, practices at the Delhi High Court and other courts, and also is the founding partner of Circle of Counsels, a law firm specializing in financial crimes. Highly appreciate your time. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.